scrap value, which means to say the remaining value of that damaged property altogether. The insurance company might definitely look into this process of saying that yes, we do find that there is some salvage value that's available. You hand over the property to us, we will give you back the salvage realization, the salvage potential or the value altogether. There are two types of arbitration. One is called as the binding, the other one is called as the non-binding. Good morning and welcome to the session 4 in unit 5 in Principles and Practice of General Insurance, where we are going to talk about arbitration, loss minimization and the salvage value. Now moving further, let's try to first get introduced to what is salvage value. Salvage value is the amount which an asset can be sold at the end of its useful life, which means to say at the end of a particular time period, once the product has been completely used, once the asset has been completed its usage value, the remaining value is known as the salvage value. In insurance circle, this word is commonly referred to the scrap value of the damaged property. So in insurance terminology, we use that word scrap value, which means to say the remaining value of that damaged property altogether. Moving further, let's try to understand the salvage value in detail. In property insurance, the salvage value or the scrap value will be subtracted from any loss settlement if the insured retains the damaged property. So first, they will subtract any kind of loss, any kind of settlement factors that has to be done for that by the insured, and then for the damaged property, finally you will get in terms of your salvage value. In extra expense coverage, the salvage value of the property purchased for the temporary use while repairs will be made in terms of deduction and determining the amount of loss of recovery. So for example, if there is going to be any repair charges, anything that has been used under the temporary purpose, all those amount will be subtracted, and finally we will be able to find out the value of the entire product or the salvage value altogether. The practice of taking salvage for damaged items is most common in motor insurance. Why? Because that is where you would be able to see that in case of any severe damage or any impact, people literally sell off the vehicle for whatever the scrap value that is remaining. So I would always say that the practice of taking salvage value is more common and more, it is found in terms of the Motor Vehicle Act. So many a times what people tend to do is that in the case of the motor vehicle, the insurance factor, they immediately go back and go into the salvage value criteria altogether. When a car is being written off and the insurer pays the claim, it takes possession of the damaged car and sends it to the auction facility or similar. So when the insured person goes further and says that, so I'm going to give away my car in terms of the salvage value, the company will take in possession of the damaged car and put it to an auction or to a similar bid altogether. The proceeds from the sale of the damaged car are for the insurer's benefit, and the offset amount claimed by the policy holder. So the whatever amount that is going to be got from the auction altogether, that will go in benefit of the insurance company and for the offset that has been claimed by the insured person altogether. So this is how we will be looking into the salvage value aspect. The next thing is that although most of the common factor in Motor Vehicle Act remains, salvage may occur in other types like household contents, for example in business stock, machinery, marine, and even in travel insurance. Why? Because even in these sectors, there is a lot of salvage value that needs to be discussed, that needs to be understood. It is usually a condition within the policy that the insurer retains the right to ask the claimant, the person who's claiming, to send the damage items upon request. The reasons are twofold. First one is that the insurer may wish to inspect, because they will first try to see whether the product is repairable, whether the product can be replaceable, or is it that the claimant just wants to claim the scrappage value as soon as possible so that he can make his profit. So whenever we talk about this salvage value factor altogether, the company will first go and ask the claimant to produce the product before them so that they can have a clear-cut vision of how things are, how it needs to be done, and then probably they go further in terms of verifying it. The second reason is that once the item is being found that irreplaceably damaged, and then the value of the item is to be paid by the claimant, then the insurer may look for an offset by its loss by offering the item for the sale. So as I told you, if in the case of a car accident or a motor accident where you start seeing that the vehicle cannot be replaced, it's beyond the replacing capacity, it's beyond the damage factor altogether, then what the insurer will do is that take the vehicle under its fold, put it to an auction, and whatever money comes, that will go to the benefit of the insurance company and to the claimant altogether. Now, the salvage value is also offered in terms of travel insurance, which is very, very important. Why? Because now it might include electronic devices such as laptops, tablets, camera, mobile phones, all those things. Why? Because the company feels that even though this item may be irreplaceably damaged, but still it has some value, a commercial value for the spare parts, for the small parts that are available there. So keeping that in mind, the insurance company might definitely look into this process of saying that, yes, we do find that there is some salvage value that's available. You can go further and claim that salvage value altogether. Now, this might be considered for any type of property, not that you just have a house, but you can also claim it for your, for example, you have a farmhouse, you have an estate or whatever is that, you will be able to claim a salvage value if the insurer considers the damaged item has a realizable value. It will be considered for the salvage potential. The most thing is that the important factor that we need to go through from an insurance company standpoint, unless and until the insurance company feels that there is a salvage potential behind that product or the asset, they are not going to just give it away. They will think twice, they will think thrice, because the factor is that if they are taking possession of the goods and the goods are not getting any realizable amount in the long run, then they are not going to give you this salvage potential. They will first look whether the product or the asset has got a salvage potential in the market. Based on that only, they will be able to get in for the salvage potential realization factor. With that, we will also start moving forward in terms of understanding when we are going to settle the claim, the insurance companies pays and damaged item for the value of the damaged item. They are within their rights of the possession in terms of the good. So they will pay it in terms of understanding whatever is within the rights, and they will take it under their possession, because going further, they are going to auction it and they are going to take the benefits of that particular product. Now, the other thing is that, however, if the insured party has the first option on the any salvage, so if I am the insured party, I would have the first option whether I want to give it or I want to hold it. This means if you want to retain the item, you can make a salvage offer to the insurance company. You can say that, sir, I would give you back this much amount, but I want to hold this particular salvage property altogether. If the company accepts your offer, you keep to get the item in addition to the claim payment. In addition to the factor of that loss, you also get to hold that property with yourself. While an insurer retains the right of salvage, if they pay your claim, they won't always always exercise it. They don't go for it every time. They say that we are not in for that kind of terms and condition. You better hand over the property to us, the asset to us. It is our duty, our responsibility to go further, put it into auction and claim our benefit. So in that condition, what the insurer will always say is that you hand over the property to us, we will give you back the salvage realization, the salvage potential or the value altogether. Every time they will not allow you to retain the property or asset with you at any given point of time. Followed by, if they do, they are legally obliged to comply with their request to hand over the item as a part of claim settlement process and the terms of the insurance policy. Now that is also going to put them on an extra edge, on an position, a disadvantaged position. Why? Because every time when they hand over that goods or that asset to you, they have to give out the legal options, they have to follow the terms and conditions, they have to give you the particular asset plus the salvage value, which is going to be quite tedious for them. Now, what is an arbitration altogether? An arbitration is a process by which you are going to use a third party to settle a dispute instead of taking the case to the court. So instead of directly going and landing in the court and presenting your problem, there is going to be a third party who is going to act as a negotiator, act as a person, the in between, the neutral judge, and he is going to settle the problem between both the parties. Both sides rely on the arbitrator, an unbiased individual or panel, to come on appropriate direction or a decision based on the facts of the case. So a neutral person will be appointed as an arbitrator who will go through the case and will come out with a decision that is fair and just concerning both the parties. Followed by the resulting judgment is called as arbitration award. Moment the judgment is given by the arbitrator, that is called as the arbitration award. It is legally binding and includes all the information about the case, followed by the arbitrator's decision regarding the fees factor, damages, disciplinary action and resolvement of the case. So with all these factors put together, whatever the fees, the damage factors and all the disciplinary action that has to be taken, all those kind of fees put together will be the arbitrator's fees at this given point of time. Now, there are two types of arbitration. One is called as the binding, the other one is called as the non-binding. In the case of binding arbitration, both the parties will agree to the arbitration award and they will not have the power of again going back to the court and re-appealing on this case. So which means to say that no matter under what circumstances, the court cannot be an option at all there, because both of the parties have agreed to the decision that is being taken up by the arbitrator, by the judge who is there, and he has told very, very clearly that yes, both the parties have agreed to my decision. So that's a binding agreement altogether. Now, in the case of a non-binding administration, which is used by both the parties, they wish to retain on however the dispute is resolved. At that point of time, if the judgment or the decision is favoring one person and the other person is not happy about that decision, then he can go and appeal the same in a high court or in the Supreme Court, depending on the factors here. So that point of time, in a non-binding case of arbitration, the person can take it to the court. Followed by the mandatory versus the voluntary arbitration. What is a mandatory? Arbitration is mandatory in cases where the contract dictates that arbitration will be used to resolve a dispute, such as when a client signs in for a commercial contract. Now, in a contract note, when it is being written that in case of dispute, arbitration would be the methodology used to solve the case in that position, in that situation, mandatory arbitration comes into picture. Now, in the case of voluntary arbitration, when both the parties opt in, saying that, okay, instead of going to the court, let us go in for an arbitration and try to settle this issue amicably, then that means we are going in for a voluntary arbitration. Why people always try to go in for an arbitration is that it is easier to settle. We don't have to go through too much of legal formalities and documentation, plus the time consumed is far more lesser rather than taking this court to the case and all those factors landing up in the court and waiting for years and months to happen in terms of getting a good decision. Now, how does the arbitration work in case of business insurance? Arbitration may be used to settle insurance dispute between the insurance provider and the policy holder. Instead of filing the lawsuit, the insurer and the policy holder both present in the case of the arbitrator. The arbitrator reviews the facts that has gone through in terms about the insurance and then presents a decision how to resolve the dispute. This could result in provider having to pay for damages it tried to deny at the first point, or the policy holder might have to pay for the damages that the arbitrator ruled out, which is not included in the insurance policy. So both ways the decision can be arrived. It might be in the favor of the policy holder or it might be in favor of the insurance company. But the arbitrator will first go through the facts of the case. He will find out to which side the decision has to be given, who has to be benefited on that, and based on which the decision shall be presented. With this, I come to the end of this particular session. I hope and believe that this session was of a great help and resource to you. In the upcoming sessions, we will learn more about the principles and practice of general insurance. Until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.